I'm gonna have you stand right here in front of the monitor.
Hello there, Mr. Jones. How are you?
Good, how are you, sir?
I'm doing well, thank you. So this is regarding case number 2026 CM003. Would you state your full name?
Robert J. Jones, Jr.
All right, sir. So this is the date and time scheduled for your arraignment. The allegations that are made against you are disorderly conduct under the domestic violence statute, assault under the domestic violence statute, and resisting arrest passively. All of those are class 1 misdemeanors and are have a maximum fine of $2,500, 6 months in jail, and or 3 years of probation. Now, as of now, the prosecutor has not filed any notice for you to have jail time. So I know that you've been in custody, but it's not been part of you being sentenced. This is all because of the offense and the things that we talked about before. So it's not part of sentencing. Now, taking that into consideration, you're not facing jail time as a consideration of sentencing. If that changes, your rights will change. So if the court does receive a notice that they want you to go to jail if you're found guilty, or if you plead guilty or no contest, we'll notify you of that ahead of time so you'll know your rights before any of that takes place. Your options are to plead guilty, not guilty, or no contest. Depending on how you plead will be what happens with the next step of the court process. If you plead guilty or no contest, I'll schedule you for a sentencing at a later date. We must comply with victims' rights notification and notify the victim of your plea. They have an opportunity to say something to the court if they wish. They don't have to, but we have to notify them, attempt to notify them regardless. If you plead not guilty, I'll schedule you for a pre-trial conference. That's where you meet with the prosecutor. The prosecutor will discuss the case with you, may share information from the police report, any evidence that they plan on using at a potential trial at a later date. So those are the three options. Right now we're doing this by video. Instead of you getting scheduled to come back to court on a whole nother day, what I'd like to do is get your permission to waive your personal appearance and do this by video, and I can take your plea, and that'll save you a court date back to court. Is that okay with you?
That would be all right, but would any of them grant me like a possibility to be OR'd?
So it's not conditional, okay? So meaning that my intentions already were to release you after today, but it has nothing to do with what the question is that I asked you.
No, I get that. It was just a random, it was just a question.
Well, it's like me asking you a question and then telling me your favorite color is blue. Okay, what I'd really like you to do is answer the question that I asked you.
Yes.
Okay, so what I'm asking you is, do you wish to waive your personal appearance so I can take your plea by video instead of scheduling you back to a court on another date?
Yes, sir.
All right, so that's waiving your personal appearance. One of the other rights that you have, sir, is the right to an attorney. Like I've informed you, you don't have a right to a court-appointed attorney because so far there's no jail time being asked. If that changes, you'll have a right to a court-appointed attorney at little or no cost. So you have to make a decision today and let me know that you're going to enter a plea with or without the representation of an attorney, or give me a reason why you need a court-appointed attorney besides you cannot afford to hire one. So it's a two-pronged. To qualify for a court-appointed attorney, you need two things. Number one, you can't afford an attorney, so we would send you a referral to see if you qualify financially. And then second, you need a cause for one. Do you have any cause that you need to make me aware of? I told you the jail time is one. A mental disability that's diagnosed by a doctor, any of that would be number two. If you don't have any of that, then you're left with one of two choices. I'm going to waive the presence of an attorney, or I'm going to hire an attorney on my own. Do you understand that?
Yes, sir.
How do you wish to proceed with the attorney decision? Waive the presence of an attorney or hire one your own?
To try to hire one on my own.
You do want to hire one on your own?
Well, no, we'll waive it.
Okay, so know this, that you can change your mind one way or the other. So let's say today you waive your attorney right now. Later you can change your mind and let us know, because we have to schedule court dates differently if you're represented by an attorney. So we'll waive it for now, and if you change your mind, just let us know.
Yes, sir. Yes, sir.
All right, do you have any questions about the pleas that I told you of guilty, not guilty, or no contest?
No, I don't.
All right.
I understand that one.
Okay, there is a mandatory minimum penalty on each of the charges that I need to make you aware of before I take your plea. Each charge of domestic violence has a $50 address confidentiality fund fee and a $50 domestic violence fund fee. So you have two of those. So that's a $200 total, $100 on each charge, plus mandatory domestic violence counseling that's required. You understand that?
Yes.
All right. Before you give a plea to the court, do you have any questions?
No, not really. So I guess on the tablet I did a bunch of those like certificates and stuff for like anger management, the 12-step and stuff like that. Does that apply to anything with you?
Well, you got to do specific counseling. It's ordered by the state by statute.
Got to go to a place and.
No, it can be done online. It depends. So what I would do is if you plead guilty or no contest, or if you're found guilty, all of this is explained to you at a later date at the sentencing, okay? So we're a little early on some of those questions, but I want to answer it so you're informed. You would have to do specific domestic violence counseling. So if you're already doing any other type of counseling, this is very specific. They're going to screen you and then assign you to domestic violence counseling. And you have choices of facilities to go to. And you can do them online or in person.
Okay, because I live in Phoenix. So
yeah, you can do them down there.
Okay.
Just as long as it's a state-approved domestic violence counseling center. And if you're found guilty, or later at sentencing, if you plead guilty, we'll give you the information that's required for the counseling.
Okay.
All right. Any other questions besides that before I take a plea from you?
No, sir.
Okay, either guilty, not guilty, or no contest. How do you wish to plead?
No contest.
Okay, and you understand the difference?
Yes. I'm from Nevada, so we have the no contest thing and stuff back home too.
All right, so for the record, I'm going to cover it anyway. So if you plead guilty, that means you acknowledge the facts and that you admit to committing the crime. No contest means that you're not admitting nor denying the facts of the case, but recognizing the facts of the case would be used at trial if the case proceeded to trial. You understand the difference?
Yes, sir.
Both no contest and guilty show as convictions on your criminal history. So I'm going to enter a no contest plea for you and schedule you for a sentencing date. That sentencing is scheduled for February 9th of 2026 at 9:30 in the morning here in Payson. I'm going to review your release conditions with you, which is obey all orders of the court, do not commit any crimes, notify the court immediately if your address changes, do not leave the state of Arizona without permission of the court, do not contact the alleged victim with any unwanted contact. So I'm not restricting you totally.
That was the one that we talked about last time. Yes.
Yeah, so you're allowed to communicate with the other party unless they request not to talk to you. If they do that, you must comply with their request or you're violating the court's order and you can be arrested.
Okay.
Okay.
So what about on the guidelines of him having my registered dog?
Well, you're allowed to talk to him. There's no you can't not talk to him until he says I don't want to talk to you. If there's property that needs to be separated, you need to call the police if you think he stole it from you, or request a civil standby to collect your property.
Okay.
Okay. The final release condition is not to go to the location of the alleged offense unless you need to get personal property. Then just make sure you get the police to go with you.
Yeah, I got to go there and check about my personal property that was left there when we came over here.
Yeah, no problem. Just contact the law enforcement agency and they'll go with you to make sure the peace is kept.
Okay.
Any questions about those release conditions?
No, sir.
Can you abide by those?
Yes, sir.
And you'll show up to court as ordered?
Yes, sir.
Okay, I'll release you on your own recognizance. Do you have any questions about anything we talked about?
No, sir.
Okay, I'll get you a copy of the court date and we'll see you on that date.
Thank you.
Yep.
All right, thank you, Judge.
And who do you want me to send these to?
You can send it to C.R. Smith.
All right, and then I've got just a review order. I don't need to see her. I don't know if I was talking to you on the phone.
Yes.
It's just to say I reviewed the case, so if we just put that in her file, that's fine.
Okay,
All right, so I'll get this one and Healy's over to you shortly.
perfect. Thank you.
You bet. Bye now.
Bye.